Mike and I have been friends for a while. We're working a class action now. He has a class action practice around the country. Has been doing it for about 47 years, and has had very mixed success. So, with that introduction, there you go.
That's good. I'm gonna get you back later. Okay, so a little bit about who in here has done a class action? Like literally litigated one or participated in one, or filed a notice of claim in one? Can I do that? Okay. All right, a little bit more background about sort of how I got into this. I think I said at the start, I was a defense guy for 3 years. I was in Washington, D.C., law school, William & Mary, get out, do defense work. I can't stand it. I got a sister who is, I'm the youngest of four, and she's an attorney in Boston, and she does, that firm does asbestos and lead paint cases. So she says to me, hey, Mike, why don't you think about getting into class on the plaintiff side? She didn't say class action. She said, how about the plaintiff side? And I said, okay, that sounds interesting. I was thinking about DOJ and U.S. Attorney, and that didn't work out. So as it happened, I got a call from a headhunter. I ended up interviewing and working with a firm in D.C. called Cohen, Milstein, Hausfeld, and Toll. And I was hired to do securities fraud type cases. Okay, that's how I started. But that firm also did antitrust cases. And at the time, they were involved in the Exxon Valdez case. We were representing a lot of the Indian tribes in Alaska. And so we had a piece of that. So I got, some of the environmental stuff. And I've done all manner of cases. I stayed in D.C. for about 3 years. Then I went to a firm in San Diego called Milberg Weiss for about 3 years. Some of you may have heard of them. They're now called Robbins Geller. And then in 2000, I moved here, and I did class actions for a long time with Carey, Donnie, and Lowe. And then in 2012, I moved to the firm I'm at now, Cuneo, Gilbert, and LaDuca. I'm still here in St. Louis. I've been here since August 2000. I'm still here. But my main office is in D.C., so I'm their St. Louis guy. And I've continued to do all manner of cases, consumer cases, civil rights cases, and all of them in the main are class actions. Those types of firms, as you may or may not know, also do many times mass tort type cases. And some of those mass tort type cases like Fen and Baycall and Resolin and mesh cases and hip cases, those oftentimes involve a class aspect, and then there's individual cases because individual cases get opted out. So you can have both sides, and I've done all of those things too. So that's a bit of my background. Now, I'm also the son of two high school teachers. My dad was a high school history teacher. My mom was a phys ed teacher. So I tend to lean towards the history side. And if you're going to understand class actions, you got to understand a little bit of history, including up to today, because it's coming around again today. The Rule 23 was passed in 1966, FRCP 23. And I'm going to talk to you about federal court mostly, but a lot of this applies in state court. And the truth is that most state courts have adopted a version of their rules that looks like Rule 23. So if you're in a state court, if you're in Missouri court, when I talk to you about the class cert provisions, it's 52.08. I think I got that right. And it's basically the same. It's the Rule 23. So I'm going to talk to you about federal court, but a lot of this applies in state court too. So that law gets passed, class action law starts to develop, and you have cases like I worked with Jerry Cohen at Cohen Milstein, and a lot of these cases started in the Northeast, in Philly, in New York, some in San Francisco, and back then it was like In Ray Sugar or like In Ray Meat or something like that. It was really basic stuff. And then the class action keeps going, and new law gets developed, and up until about the 80s, when things went crazy, class actions kind of developed sort of behind the scenes. I don't think there wasn't a lot of publicity about it. And then the 80s happened, and Bonfire of the Vanities, and that kind of took off in the class action world too. And the firm I would eventually work for, Milberg Weiss, for 3 years, although I did all antitrust stuff out there, although I was recruited in a securities case, they became sort of a target, if you will. some of you may have read about it, but in 1995, and I've got some of this at the beginning of my outline. This is the history, class actions and tort reform. And in 95, there was a concern that all these securities cases are being driven by individual plaintiffs, not big institutions. We need to fix that. And in the first and one of only 2 vetoes that Bill Clinton issued in his administration, the then Republican Newt Gingrich Congress passed the PSLRA to try to fix the abuses in securities cases. And that was the first effort at tort reform that had to do with class actions. And in the main, what happened was that they tried to take what they felt were lawyer-driven cases and put them in the hands of institutions. I'll tell you that to this day, those same lawyers are still running those cases. They've just associated with the big institutions. So, but it doesn't look a lot different than it did then. But they developed this thing called the lead plaintiff, and that's the person who's running the case. And so that was the first effort. And then 10 years later, 2005 comes, and there's another effort at tort reform. Again, Republican Congress, the same guy who I'll talk about this year, introduced a bill. He's from Virginia, and it was called the Class Action Fairness Act. Again, this was an effort at tort reform. This was the people in the Congress at that time thinking, these class actions are out of control. I'm a plaintiff's guy. I didn't really think that. And we got to fix this. And they were aimed at places like Madison County.
Judicial
hellholes. Right? So the Class Action Fairness Act, I think in the main, the big feature of the Class Action Fairness Act was to take cases out of state court and push them into federal court. So it's very difficult now, and since 2005, 12 years later, it's very tough to keep, in general, it's tough to keep a class action in state court if it's of a sufficient size. And that's because in that particular tort reform action, they said, well, if you have diverse citizenship, if you have anybody in a class action, if any member of the class is diverse from the defendant, that case has to go up in the federal court. So a lot of cases started going into federal court. And since 2005, and frankly, since 1995, there's been jurisprudence in the case law that's developed around class actions and what did the law mean and what did it not mean. This year, and I've given you a handout on it, because you may have heard there's a Republican Congress and a Republican president. There's a new bill by the guy that introduced the bill in 2005, and it's another tort reform effort, and it's called the Fairness in Class Action Litigation Act of 2017. Now, that bill, there's a Forbes article about it. You've got that in the materials. I'll only highlight a couple things. You can read it for yourself, but that bill is passed out of the House now, but it's kind of stalled. It hasn't, and when you read about it, you'll hear, I don't know whether it's going to get to the Senate. If it gets to the Senate, maybe Lindsey Graham will filibuster it because Mark Lanier, who's a big plaintiff's lawyer in Texas, had Lindsey Graham over to a party. I don't know, but it's all, these things happen. But if you read through this, basically every business, and okay, I'm a plaintiff's guy, so I would say this, every business-friendly aspect of legal jurisprudence that's come through since 2005 that made it easier to get a class case done, settled, litigated, won, this is an effort to make that really hard, make it harder. And I'll only highlight a couple. There's a thing called ascertainability. I'll explain that later. It's trying to enforce a standard that came up in the Third Circuit. There's something here about 23C4 certification. That's on the second page. That has to do with certifying a case only for individual issues, and that has become a target. It's felt that that's used to let cases linger, and they should be dismissed. If you can only get that, you shouldn't be able to get it. There's another one here about typicality. The stay of discovery in an MDL motion, that's already, most judges and courts do that. They want to make that mandatory. And then there's also at the bottom, this 23F appeal. Right. These days, and I have it at the bottom of page 2, when you're thinking about a case, you can't help but think, is there an arbitration clause? Okay? That may be the first thing you think. Certainly in a consumer case or a product case. I'll give you an example. So it's the end of 2015. Yeah, end of 2015. And some of you, probably everybody here, remembers that DraftKings and FanDuel, like you couldn't watch. It's like the VW sex commercial. I mean, it was like on every 5 seconds. Have you seen that commercial? It's disturbing to me now. But you couldn't, it's certainly if you were watching sports, you couldn't, every other commercial was DraftKings, here's the funky word, text, you win. Okay, sometime in October of 2015, some guy on DraftKings says, oh yeah, by the way, I play on FanDuel and I win all the time. Okay, and we're like, what's up with that? And we started to dig, and it became clear that there was a claim. There was, though it was basically an insider trading type claim. Okay, DraftKings guys have insider knowledge about FanDuel, and that makes it an unfair contest, right? I got a client. Happens to be my brother's roommate in Hilton Head, South Carolina. Hey, Dave, do you ever play this stuff? Oh, yeah, I got a DraftKings account. Okay. Hey, I think there's a claim against these guys. Let me talk to you about it. Would you be interested in being a plaintiff? Yeah, sure, I'll do it. Okay, we file a case. Now, that case was one of hundreds of cases that got filed when the news broke that these guys were doing this. Okay, that's October 2015. Now, what you have in your materials, and I'm going to get to some of this, I filed the case, but I know that millions of cases are getting filed. One of the things that happens in the class action world is something called an MDL. Does anybody know has everybody heard of the Judicial Panel on Multi-District Litigation? Okay. The JPML is an actual, I want to say it's its own entity. It's not really, it is a court in some sense. The JPML, or the MDL as people know it, is a body that has it's a group of about 10 judges picked from all of the districts in the country. And it came about as a result of the asbestos cases, how to get our arms around asbestos cases. The MDL now, its sole function is to meet every 2 months. And for all the cases in which an MDL motion gets filed, it has its own docket. Go on Pacer. You can search the JPML docket. It's got its own set of rules, right? And what happens is if you know that there's multiple cases around the country, you file a motion. Everybody who's subject to that motion gets a chance to comment. And then whenever that case gets set for a hearing, somewhere really nice, the MDL judges got it made. They set up a hearing like in Boca Raton or, Rancho Santa Fe or wherever the nicest court. Actually, that's not always true. Like one time they had it in Richmond. Like I went to school at William and Mary. The Richmond MDL hearing was a nightmare. It was so small. But you file a motion. I did this with DraftKings and FanDuel. I filed the first motion. Right, and it's a way to try. Okay, we're in business too, right? It's a way of trying to gain control, trying to get a position in the case, right? Because if I'm at the top of the case and I settle it, I'm the one dividing up the money. Okay, I'm also the one litigating the case hardest. So the MDL motion is a tool that is going to get used. I filed the motion. All those cases got heard in Fort Myers in sometime early in 2016. And then they sent all the cases to the District of Massachusetts in front of the Honorable Judge O'Toole. I'm on the executive committee of that MDL. There's a three guy co-lead, 3 guy and gal, 2 guys and a gal. And I bring up all of that so you can look at the motion and the memo I filed in the scheduled cases. It's in your materials. And the concepts at the MDL are: do these cases share common questions? It's kind of a we often say when you're doing the MDL, the judges know where they want to send it, and there are the statute is 28 USC 1407, and there's criteria in there about whether the cases do go to an MDL. In this case, they did. All of that is lead up to say, DraftKings and FanDuel have arbitration agreements. And they think that all of that work that Mike Flannery did from October 2015, Mike Flannery and all the other lawyers in the country did from October 2015 when this news broke till now, should all go to arbitration. Cannot be heard in court. So, that's these are tough issues. We may or may not win. We've got arguments, but the arbitration and the primacy of the Federal Arbitration Act makes it difficult for what we do. It's sometimes if that company hasn't got an arbitration clause, that could be a gold mine for you because most of them do. So you're gonna have to be aware of that at the start of your case. Is that something you got to think about? As I say, are there other cases that are underway? Is my liability case strong? This is basic. You got to do your research and you got to think about it, and you got to talk to witnesses, and you got to dig, and as you think it through, if you come up when you decide that the answer to that's yes, and you have a client, somebody who's retained you, and by the way, when the client gets the deposition, yes, defense counsel will ask you how that relationship came about. So you will have to consider issues relating to solicitation. It's not solicitation to talk to your friends about whether they have the issue that you're looking at. But you're going to have to pay attention to that, and then then you're down to writing the complaint. Okay, that's what you do that next. You got a client, you're writing the complaint. You need to think. You need to think about a lot of issues in the complaint, of course, about the substantive allegations. But you've got to think: am I going to do this in federal or state court? I just said, and I still believe it's hard to keep them in state court. But maybe you have that purple unicorn case that you can keep in state court. If you do, great. Honestly, I got a case right now, and it may be because Governor Greitens is in office. There's a case I have now against Massage Envy. Okay, and it has to do with the fact that we say they misrepresented whether their hour-long massage was actually an hour long. And there was a federal case over in Illinois in front of Judge Herndon, and that case is sort of trundling along. And I filed. I know the lawyers in that case, and we decided we were going to do some work together. And I filed a case in state court in Missouri because I have a Missouri plaintiff. They didn't remove that, even though Massage Envy is an Arizona corporation. And I was surprised. I thought for sure that because they have diversity of citizenship and under CAFA, they would have the ability to remove me. They didn't do it. And I wonder whether that's because they think that my claim is worthless in Missouri State Court. That's possible. So, you're going to have to decide where you're going to file. There's a thing in your materials. It's the Generac order. I filed this case just a little while ago up in the Central District of Illinois. And this is just, things you got to pay attention to. File the case. 5 days later, the magistrate judge issues an order to show cause why our case should not be dismissed for lack of jurisdiction. And they said, you haven't properly alleged jurisdiction. We alleged that Generac, and I can't remember where they're headquartered, but our client is in Illinois plaintiff. And what we said was that he was a resident. In the complaint, we said he was a resident. And if you read that order, the magistrate judge has said it's become perfect. It's become a sort of an issue in the Seventh Circuit that they base their jurisdiction strictly on citizenship. We use the word residence. Residence doesn't equal citizenship. So we had to file an amended complaint saying, yeah, he's a resident and he's a citizen of that county. and we're off and running. But, you got to pay attention to these little things. Okay, a little bit about this class definition. How am I doing, Gary?
You're doing great.
Okay, all right. Class definition. I'm not really sure. Quarter after? 20 after. I didn't look. I should have. I want to talk to you a little bit about this ascertainability thing. As you obviously, okay, not obviously, but of course, your class definition is crucial in your case. How you define who is or is not in the class is really important. For all the reasons that you think it would be, the determination that a class should be certified is a due process decision. If the federal judge says, or even the state judge says that case should be certified as a class, and the definition of the class is certified, everybody who's in that class is now subject to whatever else happens in that case. Okay, so if you get a class certified and then the judge grants summary judgment, you're all gone. Okay, and conversely, you get the class certified and you get a great judgment, and maybe that company just bet, maybe that was a bet the company move, right? So you need to be able to define it, and what the federal courts have read into Rule 23. It's not in there. This is an implied standard. But it's across all, it's well respected by all the courts, although there's differing standards. And the question is, can you ascertain who is in the class? On at one end of the scale is the Third Circuit, which says very strictly, you not only have to define the class by objective standards, like all persons who bought Massage Envy massages between 2001 and 2004. Okay, that's an objective standard. But you also have to be able, the Third Circuit would say, there has to be a feasible way for people to show that they're in the class. Okay, so it's not enough just to define it by objective criteria. You have to be able to show by some proof that you would be able, or the people in the class would be able to identify themselves as being in the class. Okay, so what does that mean? I have another case. I don't know whether you got it in the materials, but this is you can pass these around. This is called the In Re Morning Song Bird Food Litigation. This is an order from March 31st of this year. By the way, the Driscoll firm, John Driscoll and Dowd and Dowd, our lead counsel in this case, even though it's in the Southern District of California, they are lead counsel along with my old firm, Robbins Geller. There's a really good discussion of ascertainability in this. I won't go into a chapter and verse, but basically defendants will come in and say, there's no way that anybody can show how they'd be in this class. I don't keep records. I don't sell to consumers. I don't even keep, even if I did sell to consumers, I don't keep track of those names. How am I going to know whether the person's in or out of the case? The plaintiffs come back, this is one example, and say, that's not a problem. We're going to subpoena the third-party retailers to whom you do sell. They keep records. And by the way, we believe that this is a type of case and type of where it's sufficiently unique that an affidavit from the person in the class stating that they had purchased this would be sufficient to get over this ascertainability hurdle. So, this ascertainability thing, it kind of comes into the concept of preventing fraud, but who's really going to want to commit fraud on if the consumer product is a relatively low price product? On the other hand, if it's a really high price product, we probably have some good idea that the persons who were selling it kept track of and we can subpoena them so we can go get the records. So you'll see how the judge dealt with that in that case. But it's another hurdle you're going to have to get over in the class certification context. I talked to you about MDL proceedings, class certification, and the class motion. Okay, first of all, very basic. If you're in a court like the Central District of California, and this is true in any court, but you better check the local rules. In the Central District of California, they have this 90-day rule, which if you and the defendants and the court don't agree otherwise, you got to get your class motion on file within 90 days of filing your complaint. That's tough. Most of the time that I've been in cases in that district, we, along with the defendants, ultimately come up with a stipulation, usually accepted by the court, that lays out a schedule both for discovery and briefing, and you won't be pinned to that. But if you don't pay attention to that at the start, you're going to be in a world of hurt with that judge. I put in a bunch of headings about discovery. The reason why I put all that in there is that, how can I put this? In the class action context, I talked to you about all those tort reform efforts. As those tort reform efforts came through, the jurisprudence, the legal opinions that continued to develop, showed that over time, as you come to the class certification decision, the judge who's looking at your class case is going to be asked to look very carefully at the merits of your case. Why does that matter to discovery? My experience is that, it used to be the case when I first started practicing that you could kind of file almost a rote class motion, and you could, I wouldn't say that you parroted the numerosity, typicality, adequacy, predominance, superiority, commonality, but very often the brief was not really supported by much evidence. It was really it was very much a sort of legally articulated, we get over the standard. Now that doesn't work. I talked to you guys a little bit while ago about all this Daubert information. In the class context, Daubert comes in at the class certification stage. In that case where I had the Daubert hearing on April 17th, I have already fully briefed class certification. And that class motion came after a year and a half to 2 years of discovery. So why do I do that? Why do we do that? Why are you likely going to need to do that? Because when the judge is looking at your class certification motion, they're looking at the merits too. They're peeking behind the class cert steps, and they're trying to make a determination about the merits. There's case law that sort of is all around that notion, but it has definitely changed from the notion where at one point, maybe in the 80s, 90s, even into the mid-90s, there was a lot of case law that said at the class certification stage, the judge and the court should not look at the merits at all. And that's changed. It's like the pleading standards. It used to be notice pleading. It's not that anymore. It's Twombly and Iqbal. Okay? Your pleadings have to show that you have a plausible way to succeed, right? Class certification, same kind of thing. You're going to have to support what you say, numerosity, typicality, commonality, adequacy, predominance, and superiority with real evidence. Okay, in that Whirlpool Ovens case, I've got to come in with my expert report. I have to have a lot of internal Whirlpool documents. I've got to show the evidentiary underpinnings of my case and tailored to the particular prongs of class certification. I won't go through all of them, but you're not going to be able to just come in and parrot the statute. You are going to have to show real evidence that shows that your plaintiff's claims are typical and that there are common issues. So on class certification, almost the big fight on class certification is usually, in my experience, in two areas. It's usually not on numerosity. Honestly, it's not usually on typicality, although in the tort reform bill that's pending, they try to make typicality into you have the exact same damages as everybody else in your class. Whew, I don't know what's going to happen when we get to that. But if they get that passed, that's going to be difficult. But what I've found is that in class certification, the big fights are around predominance of common issues and superiority, and in that sense, manageability. Is the trial manageable? Okay? Predominance of common issues usually comes down to this. I'm the plaintiff. I say focus on their conduct. And if I'm in a product defect case, I focus on was their product defective? Overwhelming common issue. If you tell me that's true, then I probably win warranty. I probably win breach of implied warranty. I probably win Unfair and Deceptive Trade Practices Act if that common issue gets tried first. So I'm sitting there, my arguments, all my papers say, focus on the defendant's conduct. Whether or not their product was defective is an overwhelming common issue. And of course, the defendants say, oh no, that's not the common issue. The fact is that there were millions of ovens and millions of plaintiffs, and they all have different stories, and it'll be absolutely overwhelmed by individual issues. The judge has to sort all that out. The other part is superiority or manageability. And this is, you got to be ready to say this now, and I've done a couple trials. You've got to be able to look at the judge and say, here's how I'm going to try the case. You have to be able to do that at the class cert stage, like it or not. And I put in a case, it's the Helmer versus Goodyear. That's the Entran 3 case, which unfortunately I did not win. We did not win, but we tried it. When he certified that case, and what you have in your materials is Judge Jackson, the District of Colorado's opinion certifying only the liability issue. I'm getting back to this C4 issue. We didn't ask him to. We didn't ask him to certify B3 class. And a B3 class means that the class is uniform and can be tried with liability and damages. That's B3. B2 is injunctive relief. Liability and injunctive relief can be all tried, and the class is uniform. C4 is this concept that I want to advance the ball in the case, and if we only try the issue of liability, that's going to solve that for all the plaintiffs across the case. So, Judge, please just certify the issue of liability as to the defendant. In that Entran 3 case, he did. And we tried that case. We didn't win. It was tried to a jury, and we appealed to the 10th Circuit, and we're unsuccessful. Expert testimony was at issue there, and as it turned out, the jury, all-woman jury in downtown Denver, Colorado, they liked Goodyear's expert better than they liked my guy, which was shocking to me, but it happened. I thought I had the gold standard. I love my guy. I still do. He's a brilliant guy. But the truth was that the jury just believed their guy more. Honestly, that's what it came down to. Okay, so at the class search stage, you got to be able to tell how you're going to try the case. And let me just hit a couple of other pieces here. We talked about Daubert. We talked about class certs. One other trial story, because it's in the materials. It's actually it's the favorite moment of my entire career up to today. So I want to tell it. There's two opinions in there, and it actually relates to the MDL because the judge from those cases is sitting on the MDL, and she's awesome. Her name is Judge Vrattle out of the District of Kansas, Catherine Vrattle. You have two opinions. One is from 1995. They're both law versus the NCAA. Nutshell, that case involved, okay, so in the 90s, when the NCAA had these exploding athletic budgets, they had these massive meetings about how can we solve this crazy exploding athletic budget crisis. They came up with one rule. It was called the restricted earnings coach rule. The restricted earnings coach rule said that what we'll do to solve this massive exploding athletic budget crisis is to limit the lowest paid coach in every sport to $12,000 a year. Right. They didn't say anything about the $7 million contracts or the shoot stuff. They said, we're going to limit the lowest paid coach in every sport to $12,000 a year, no matter where they are. If they're in San Francisco or East Nowhere, Idaho, $12,000 a year. Turns out that's illegal under the antitrust laws. And that's known as a monopsony, which means you can't collude on what you'll charge. That's a monopoly. You also can't collude, as it turns out, under what you'll pay. And all these member institutions were agreeing, they were competitors, and they were agreeing to only pay people a certain amount illegal. The 95 opinion, Judge Vrattle finds against them on summary judgment, right? My favorite is absolutely the best moment for me. We went to trial on the damages, okay, in the District of Kansas, Kansas City. I was out at the San Diego firm. It was 98. So I'm 7 years out of law school. I'm not sitting up at counsel table. Okay, I don't have that. I didn't have that experience then. But what I did get to do was I got to be the witness wrangler. So my guy, who was a really good, awesome trial lawyer, a really good friend of mine, would call me up and go, I need a football coach, or I need a hockey coach. Go get me Superman. And what we had to do in that trial, only on damages, liability was decided, was show that the $12,000 a year a rule had an impact, a measurable impact on the coaches, on the class. It was an awesome trial. All the witnesses were young college coaches. So, as a witness guy who was preparing them, all I had to do was say, that guy from the NCAA behind the podium, that guy's the enemy, and we're not going to give him anything. And the best moment of that trial involved Judge Vrattle and a witness whose name was Jennifer DeHanens, who had been a assistant volleyball coach at Michigan, but had to give up her job because she couldn't afford it. She had kids, she loved the sport, but she couldn't afford that. So I prep her, and I'm telling her, listen, when you get up there, and my friend Bonnie Sweeney was up there and she was going to question. I said, if Bonnie's questioning you and things get emotional, that's okay. That's just natural. Just you tell the truth and, give them what they need. So Bonnie goes through her direct and she's questioning Jennifer. And Jennifer is like, 6'3", blonde hair, looks like she's born in Nebraska, corn-fed. And it's in front of a jury of Kansas City men and women, so Midwestern stock. And Jennifer's testifying, and Bonnie's taking her through the direct. Did this impact you? Yes. Was it difficult? Yes. And at some point in the questioning, she starts to cry. The NCAA guy gets up and he goes, sidebar, Your Honor, sidebar. And they walk up, and no one heard it. You only got it later in the trial transcript. And the guy's name was Alan Saltpeter. That was his actual name. Alan Saltpeter. Saltpeter. I called him Saltpeter. Saltpeter stands up, and that's a sidebar. It's Vrattle, Saltpeter, and Dennis Stewart, the guy who was the main lead guy. And Saltpeter, you read it later in the transcript, and it's this day. Saltpeter says, Your Honor, this trial is about damages. Liability has been conceded. This is an outrage. The witness is crying on the stand. And Judge Vrattle looks at him, and Dennis said later, she looked directly into Saltpeter's eyes and said, counsel, I did not see the witness cry. Yes! And she goes, objection denied, sit back down. And Dennis said that the only thing he could remember about that moment, aside from the hilarious sidebar, was that he was watching one of the guys in the jury box, and he was sure that the guy in the jury box was going to come over the rail and like choke out the NCAA lawyer because he was so mad. Anyway, turns out, we won. The other opinion you have is the 10th Circuit opinion affirming the $21 million verdict that was tripled to $67 million, which the NCAA settled on appeal for $54 million. And the truth is that Jennifer DeHanens and the track coaches and the hockey coaches and the football coaches, they got real money for real injury, for a real wrong that was done to them by real institutions who needed to be held account and who were holding up the middle finger to everybody, because that's what the NCAA was, honestly, kind of still is. So that's Mike Flannery's way of saying class actions can have real impact on real people for, real dollar amounts. I have a stuff here about settlement, mediation, preliminary approval. If you don't get a judgment, but you get a settlement, you've got a lot of work ahead of you. That's all I'll say. You now have linked arms with the defendant. You've got to craft a settlement agreement. You've got to get that settlement through preliminary approval. You've got to send notice out to everybody. You've got to allow for opt-outs and objectors. You've got to have a final fairness hearing. And then there's going to be claims administration. So if you can litigate hard enough to get there and you got the person to say, we have a deal after mediation or whatever it is, you have a lot of work ahead of you, but it's worth it in the end. So I think.
Thanks, Mike. Great job. I would add, there's a couple that you made me think of, a couple class action things, then we're going to break, and then we're going to do liens. If there's mandatory arbitration, a lot of times they say you can't class action those. But I've also had cases. I had large groups of cases against Sanford Brown, other for-profit schools. Sometimes take that arbitration case. You can also, if you don't get a class action, you can do individual cases. The bad thing about arbitration clauses is you have to arbitrate. The good thing about arbitration clauses is you got to arbitrate. You go in, you have no discovery. You go in, do the case, you try it, you see what you do, and then you can have that pressure. So that doesn't kill the thing on arbitration. Yep. You never know where the cases come from. I had a series. There was a case out of the Washington, a district court case that said that contraception, if you exclude contraception as part of a health care plan, it's sex discrimination. So I ended up suing Daimler Chrysler and the state of Illinois. We did all these cases. And so you never know where you see. You also environmentally scan for the legal theories you see. I saw that case come out of Washington. We had a host of cases. We actually got contraceptions. The state of Illinois changed their program, and sometimes you affect change even if you don't. We won, but not a lot of money. But whatever, we affected change, which is great. And then the other thing is too. So Mike or I, we have these. We have these forms. So if you need form petitions, if you need to know how to add a class allegation into a petition to then do class-wide discovery and take a turn, see what you do. I had a case where we had, I was doing some employment discrimination cases. We found out some fraud was being done by a car dealership. We ended up doing some discovery, and then you find it out, and then you can do your case. So you can, if you need, sometimes you want to collaborate with other lawyers, and guys like Mike or me have those discovery and those forms, and also, but these are also tough cases, and you put a lot of time and money and effort into cases, and you don't always win, and so sometimes it's good to spread the risk and to by doing that. Mike and I now are in a case where we're certified. We got the class action certified, and Mike came in to join me in the case where we're representing about 11,000 Department of Corrections officers against the state of Missouri in what's called a donning and doffing case, or a pre- and post-shift activity case, and we're set to try that case in November. We're certified. We've done a ton of work, discovery and stuff, but it's good to spread the risk too. So those are a couple other thoughts that I had to add to the great points that you made, so thank you.